up. I can't.
It's Mr. Mkhize, Chair.
Mr. Mkhize? Okay, we'll take it as a lingering hand. If he wants to come in, please do so, Mr. Mkhize. Declaration.
Sorry, the lingering hand, sorry.
Okay, thank you, sir. Declaration of interest. Any verbal declarations? Otherwise, I would like to request members and as well as members of management to declare any interest that they may have in relation to items that are on the agenda and submit the declaration forms, the completed declaration forms to the Secretariat. On that note, we'll then move on to item 5, which is on the registration of applications for 29 generation facilities. Mr. Hore, I'm not sure who is taking us through. Is it Mr. Mwanza?
Chair, can I just come in before that?
Oh, yes. Sorry, apologies, Mr. Mavuso. Sorry, I didn't allow you to have introductory remarks to the submission. Yes, you may come in, sir.
Thank you, Madam. This submission will be presented by Rendani. But I just wanted to highlight maybe 2 points. One of the points is that in this addition to the 6 we already have pending this 2 others that are coming, and we are also having like very fruitful discussions with prospective that we have been tariff might be a problem. In fact, the president is taking a preliminary legal view on that provision. I've briefed the FTRM on this one, and it is something that I would want it to be debated at the ELS, in fact, through the permission of the FTRM. But with those words, I'll give it to Rendani to present the submission. Thank you very much, Chair.
Rendani, over to you.
Okay. Morning, everyone, and thank you, Chair. Thank you, Chair. This submission is a registration applications of 29 generation facilities in accordance with the licensing exemption and registration notice number 45266 of 5 October 2021. The purpose of this submission is to request 25 generation facilities for own use, and as well as to approve the issuance of registration certificate to 4 generation facilities for commercial purpose, as well as note the power parties agreement between the 4 generation facilities and their respective customers, and also note the tariffs between the 4 generation facilities and their respective customer, and lastly approve the draft decision and reasons for decision document for each applicant. Chair, the principles of the notice are that any qualifying generation facility, the licensed distributor or network service provider must assess the request for the connection of the proposed generation facility to its network, and the concerned applicants have connection approval from the licensed distributors. The municipal networks. These 29 generation facilities will have a total capacity of 13. They've also complied with the registration requirements. Therefore, it's recommended that and reasons for decisions for each applicant. Thank you, Chair.
Sorry, I was on mute. Thank you so much for the presentation. Members, the submission is before us of the 29 applicants, 25 are for own use and the 4 are for commercial purposes. Any comments or issues of enhancements, members? I don't see members that we move on to page 9, paragraph 15, on the recommendations made on the 29 applications. I will read them in for the record. The REC is requested to approve the issue. Yes, sir. Sorry, I was looking down, Mr. Gumete. Yes, you may come in.
Yeah, it's Mr. Mkize here.
Mkize, apologies.
Okay, no problem. I just wanted to. First of all, I'm supportive of the recommendation. What I just wanted to highlight is maybe it's also going to be important for the team to give certain trends that they are observing in terms of these registrants. I see that the farms that it seems like if you want reads the name Puderay and all that, also the I would say the malls, or you get these certain properties, but I just want to check that, because it seems like the normal sub grid is now left with the poor, if I can put it like that. Normal the generation slowly. So I'm saying that I'm just looking at it, at a glance, but I'm saying that maybe in writing there must also note some certain trends or observations that are worthy to note and maybe highlight to the policymakers also to do something in that regard. And the other thing is that the figures that you are observing yeah, I don't see anything in that. So I just wanted a reflection on that, just for us to understand, because we don't want to talk out of 10 when we talking about the 100 megawatt out there.
Okay, thank you, Mr. Mkize. Maybe just for my clarity, because I thought we had requested the team to submit regular reports on the applications that have been received for registration, not regular. I think we said twice per annum. And then based on that, I thought they were going to then indicate the trends that they are picking up. Or is your expectation that it should be in each and every submission? So I thought to minutes whenever the report comes in. And I think where it's necessary, there can be an indication in the submission. May I request members that we move on to P9 and paragraph 15. And in terms of the recommendation to the REC, where the recommendations are that we firstly approve the issuance of the registration certificates to 25 generation facilities under Table 1 that are generating for own use. And secondly, we are to approve the issuance of registration certificate to 4 generation facilities, also under Table 1 for generation of electricity for commercial purposes. And thirdly, to note the power purchase agreement between the 4 generation facilities and their respective customer. And fourthly, note the tariff decision attached for each applicant under Appendix D. Members, in terms of, for completeness, before we move on to vote, maybe the order approval, let me read Table 1, the list of that is in Table 1 for the record. The first applicant is capacity 0.220 solar PV, and it's in the Eastern Cape province. And the second applicant is Volkswagen South Africa Pty Ltd. Capacity is 1.400 solar PV. It's in the Eastern Cape province. And the third application is from Fargo for Pty Ltd. And it's 0.142 solar PV, and it's in Gauteng province. Applicant number 4 is Resilient Properties Pty Ltd. Capacity is 100 solar PV, and it's in the Limpopo province. And applicant number 5 is Resilient Properties Pty Ltd. 1.1 capacity solar PV, and it's in the Limpopo province. 55 solar PV, and it's in I think it's Gauteng, Springs Gauteng. And 7, it's Linwood Lane Properties Pty, 0.3 solar PV, and it's in Gauteng province. Applicant number 8, it's Bosan Holding Pty Ltd, 0.35 solar PV, and it's in Gauteng. Applicant number 9 is Katale Square Pty province. Applicant number 10 is Gyron Brewery Pty Ltd, 0.1296 solar PV, and it's in the Western Cape. And number 11, it's Gyron Brewery. Again, it's 0.1069 solar PV. It's in the Western Cape. Applicant number 13, it's Akane Mall Pty Ltd, which is 1.00, and it's solar PV, and it's in the Gauteng province. Applicant number 14 is Terradu, pardon for my pronunciation. Terradu 3 Pty Ltd, it's 0 in the Gauteng province. Applicant number 15, it's Landbank Fars Productor Pty Ltd, solar PV 0.150, and it's in Limpopo province. Applicant number 16, it's Dorenfontein Braak Trust 0.240 solar PV, it's in the Northwest province. Applicant number 17, Johannes Paulus Otto 0.240 solar PV, Northwest Province, applicant number 18, Interstate Clearing 060 Pty Ltd, and capacity 0.234 solar PV in zero solar PV. It's in the Gauteng province. Again, another application from Redefined Properties, capacity of 0.166 solar PV in the Gauteng province, and applicant number 20, it's Emira Property Fund Limited, capacity of 0.270 solar PV. It's in Gauteng province. Applicant number 22, it's 0.440 solar PV. Ltd 0.350 solar PV. It's in the Northern Province. Applicant number 24 is Resilient Properties Pty Ltd 1.00 solar PV. It's in the Limpopo Province. And the last one that is for own use, it's applicant number 25. It's Kinetic Capital Pty 0.440 solar Zulu Natal. Moving on to those that have applied for registration for commercial purposes, it's the first one is Next Renewable Generation Pty 0.160 solar PV in Gauteng Province. The second one is Synthesis Power Solution Pty Ltd 0.350 solar PV and is in the Eastern Cape. And the third one is Synthesis Power Solution, again Pty Ltd, and the capacity is 0.236 solar PV. It's in the Eastern Cape. And the last one is Synthesis Power Solution, again Pty Ltd 0.236 solar PV. It's in the Eastern Cape province. Members, those are the list that have been read into the record with regard to registration certificate for generation of electricity for own use, and also for the second one was for commercial purposes. On that note, members, by show of hand, may I request that you give an indication of whether generation for own use. To also note, sorry, I've been looking down, members. Thank you. I also support the application. Thank you so much.
Chairperson, your mic is muted.
Apologies. May we then move on to the section on the petroleum pipeline regulation submission, item 6. Martin, if you can direct us who's going to.
Thank you, Chair. I see Ms. Mtua has joined, but based on what we've agreed, I will proceed. Mr. Lukele will do the submissions, but please allow me maybe, and then we'll be quiet on the second one. Just the context for the members that these two submissions, 6 and 7, which may ask why are they the same or seemingly the same. It is because the one that did not make the cut-off date for the earlier meeting, and it was transferred to this meeting. And then item 7, which may look similar also then, is for noting and approval in your report, which is the APP requirement. So having said that, we back to item 6. Mr. Lukele, can you please just highlight the key items? Thank you.
Thank you, and thank you, Chair. Good morning to members and everyone. The purpose of this submission is to request the REC to approve that certain storage facilities do not require licensing as provided for 15 subsection 2A of the Petroleum Pipelines Act of 2003. The details of the storage facilities are provided from paragraph 20 of the submission. Just to summarize, the first facility, it is an existing facility owned by Mass Petroleum, located in Sasolburg. It has a combined design capacity of 46,000 liters, and it's said to be used for wholesaling of diesel. The second facility, it is not yet constructed. It is planned to be constructed by X Fuels in Harrismith. It is planned to have a design capacity of 79,000 liters. It will also be used for wholesaling of diesel. Both these facilities are way below the current threshold of 1,500 million liters and are therefore recommended to be excluded from licensing. With that, Chairperson, thank you.
Thank you, Mr. Lukele. Members, the submission is before you for consent. This is your opportunity to raise questions or any issues of clarity. Thank you. Mr. Gumede?
Thanks, Chairperson. And maybe this is a matter that I just need to be clarified on. I have read that the actual delegation indicated, the authority indicated, the authority indicated in paragraph 3. I just got a bit of a concern around, perhaps the delegation between REC, what matters are delegated to REC versus matters are delegated to the PPS, especially if it's issues that are actually new. For instance, the actual use of 15(2)(e), 2A, is that I would have assumed that something like that would have been better deliberated at the Petroleum Pipeline Subcommittee, with the view that for me, it's really about having an opportunity, giving an opportunity to part-time members also to participate. I do recognize that at this stage, we do have an issue that we are largely comprised of full-time members anyway. But I do request that this issue of this delegation be looked at. There's something to me that does not look good with this being discussed only by of the regulator. That's one. The other issue.
Mr. Kumar, just sorry to interject you. I think on the first point, maybe may I request that it be discussed in a closed session, so that we can allow the RSU team to respond to it, because it sounds as if it's an internal matter which once decided upon, and then it will go to the open session. Or I don't know. That's my view. Do you mind if we do that?
Okay, ma'am. I'm okay with that recommendation. Thank you.
Sorry.
That's fine. So I guess then I was then looking. I know that the team has indicated that we draw the powers to is that section 15(2)A meant to give the members of the regulator blanket power to decide on whether something is or to actually decide on whether something needs to be licensed or not? Or is it supposed to be, or is that discussion meant to be curtailed by the definition? That's number one. But I guess linked to that is also, and maybe it is linked to be recommended to the
get clarity with regard to table 1, whether those comments from REC that were made in 2021 in November, are we now considering them as a standard guide in terms of dealing with such applications? Because I've noted them in the next application, in the next submission rather. So if colleagues can just clarify that for me as to whether the table 1 is sort of a standardized guide now or not in terms of considering this application. Thank you. Martin, I see your hand is up.
If the EM wants to comment, but from my side, maybe if I can start with that question, Chair. Yes, that was a specific request by the REC. And apologies, I should have maybe highlighted that aspect in introducing the matter. So to answer your question, yes, the verification involving this matter, that we agreed that we actually enhance the verification process. So yes, that's the answer. That's the standard practice. In terms of Mr. Kumedi's question, and then more the second one, based on the discussion on the other matter to be done in the closed session. Yeah, Mr. Kumedi, we based this on 2 external senior counsel opinions, which NERSA at the time got, which basically clarified that, and that is on what it is based. Technical team is that there is no and what we've seen is that bulk can be anything from 2,000 liters in the literature to 200,000, which is the technical standard for SUNS. So I think it's because there is no definition, and this has been communicated in terms of what amendments to the Act needs to be proposed by the energy regulated matter. But yeah, there is no definition in either the Act or the regulation. I hope I've answered the questions, Chair.
Yes, you have. Mr. Kumede, are you? Oh, there's a follow-up from Mr. Kumede, Martin. You may go ahead, sir.
Thanks, Chair. Thanks, Mr. Untid. I was more thinking, you see, my question was more relating to this that says was more related to section 15(2)A now. That says, we are saying that in terms of section 15(2)A, if I can quote it verbatim, is that it's the energy regulator may decide, the authority may determine whether any person engaged in the activity requires a license. Now, the issue though is that 15.1 has got a particular requirement And also, I guess what I'm asking is that can 15.2 be taken on its own, or should it be read in conjunction with the definition, for instance, of storage? That when storage is defined, it does come up with those exclusions. 15.2 be read with that definition of storage, or can it be read on its own? I'm just asking because it seems to me that we could then, that could well, it looks like an unfettered discretion for the regulator that in fact we can choose to exclude almost anything.
Yeah, Chair, if I may, and maybe the legal colleagues should assist me because I'm definitely not the legal expert, but I think that is the way I understood it from our engagements with the senior counsel, external senior counsel, that you can't just read one element like you correctly indicated. So it has to be viewed with the whole section. That is I think that is absolutely correct, but maybe I'm not sure if on this, but I'm not sure. There will be a submission at one stage coming back to the PPS on this update on the whole determination and the engagement with the department on this, and maybe then we can bring it in that submission to thrash it out, if I may use that term. I'm not sure if Laz wants to assist me.
Chair. I'm not sure if my question is clear though, perhaps, because all I'm asking here, maybe just if before Laz comes in, all I'm merely saying is 15.2a gives the regulator an authority to decide on persons that may not need a license. However, 15.1 also is very instructive. But what I was asking was that 15.2, is 15.2a not supposed to be read with the definition of storage? That is my question.
Yeah, I think that maybe I put it badly. Yes,
maybe let's
it has
allow
to be, but yeah.
Assist Mr. Mboniseni interpretation of statute. There it comes, and may you assist.
Chair, I wouldn't want to mislead the meeting. When this discussion took place, my colleagues were sitting in, and I think they're not in the meeting today, that as Mr. Ontita has highlighted, that when the submission comes back, this issue could be clarified and there'll be a specific reference to the issue that Mr. Gumede is raising, so that we do not delay the meeting giving interpretation in a meeting, Chair.
Okay, I saw another hand. Lillian, please help me. I'm not sure whose hand it was. Oh, yes.
With what Mr. Morati has just said, but I think, Chairperson, we can actually give this meeting comfort to say 51 and 52 are so directly linked. Actually, what 15.2 says, while you have to actually the license can be issued to you when you or those facilities, is that the authorities, the energy regulator, that says what you are doing is actually you are constructing that or actually doing the loading facility. Therefore, what I'm saying is then the 15.2 says is the ER that says you are doing what is in 15.1. I agree with you, Mr. Gumede, to say indeed we take the whole definition of all the aspects of this license when we are in 15.2. Therefore, my answer, Chairperson, is that we consider all those elements of the license. But 15.2, what it just says, it says when you think you are doing that, it's ER. We think it is the thing that is licensed. Therefore, if you read it, you'll just say is the authority that determines that whether what you are doing in 51 is what ER regarded as the thing that is licensed. I don't know, Chairperson. I think I'm trying to say, indeed, we consider all those definitions that are the aspect of these licenses. Therefore, the 15.2, ER doesn't have an unfettered right to just close their eyes to say it is or it is not. It is the one, what it says, it's not the applicant that says I'm doing it, therefore it is. It's the ER that says what you are doing, yes, is within what we regard as a licensed activity. Thanks, Chairperson.
Are you sufficiently answered, or should we also allow the team to just come up with the write-up in terms of the interpretation of these particular sections 15.1 and 2, and as well as the definitions and how all of these should be taken into account when considering a submission? Mr. Gumede?
Chairperson, actually, it's that reason why I will not be able to support this, because from where I'm sitting is that I don't think we need to interpret the law. We can't write the law. And from where I'm sitting is that this is asking us to actually decide whether something requires a license or not, even if it meets the definition of storage. Now, for me, I'm a bit concerned about that we can't give ourselves powers we don't have. So from where I'm sitting, I will not be able to support this, unfortunately.
Okay, noted. Mr. Mkize, do you want to come in so that we can close this matter? Mr. Mkize.
Thanks, Chairperson. Where I'm sitting is that I don't want us to unduly create more work for the legal people. I think that happen is that legal interpretation must be part and parcel of that report. The whole issue of the bulk determination, as well as other matters that are related thereto. I taken that we take incremental decisions and observe precedents. The bulk determination is in place by the regulator. We've looked at it and tested it. So for now, it is what but I must still say that there is progress made, and hence a report will come to serve whether here or at PPS, depending on the delegation matrix. So it is a matter that will be attended to, and all members of REC will, as they are part of the regulatory subcommittees, will also deliberate on these issues. So it is on that basis then that I'm putting forth put an extra I did not comment or ask any questions because it bears my signature. Thank you.
Thank you, Mr. Mkize. I also signed the submission because may I then request members that we go to the recommendations which are it's paragraph 41 The REC is requested to approve the following two storage facilities. Let me read it again. It is recommended that the REC approves that the following two storage facilities do not require licensing in terms of the Petroleum Pipelines Act, and those facilities State Province and X-Fuels proposed storage that's still going to be constructed, storage facility in Harry Smith in the Free State. By show of hands, members, can we, and also I think we need to note that there is going to be a report on the bulk determination that will be brought to the relevant committee or subcommittee, and that report should cover the issues raised by Mr. Gomede and any other sub-applications will paragraph 40. Yes, I also support the approval of the submission. Mr. Gomede, we will note that you have indicated that you will not be in a position to vote. Thank you. On that note, members, may I then request that we move on to the next item, which is item number 7. Mr. Untit, or is it Miss Mutwa? Can we, colleagues, because time is really not on. Coming item 7?
Yeah, I want to then place the chair the report on all these decisions taken during the past year, which is related here in terms of this specific matter. Mr. Lukele, just 1 or 2 sentences on it.
Oh, thank you once again. 1 or 2 sentences, I'll try. As indicated, this report it's as per the APP and is here for noting. It also contains by owners seeking confirmation of whether their activities require licensing. There was only one matter that was brought to the attention of NERSA by concerned third party, and that is discussed from paragraph 36. And states for financial year, it's provided from paragraph 23 of with a combined capacity of about 79,000 liters, does not require licensing. And secondly, the other facilities by Stark Club Ross in the Western Cape province, with a combined capacity of about 76,000 liters, does not require a license as well. With that, Chairperson, thank you.
Thank you, Mr. Okere. Members, any questions? Points of enhancements? Mr. Mkiza, your hand is up. I assume it's a lingering hand. Page 22 to 30, or rather, let's go to page 30. There's a footnote there that is given to say that the 204 number that are on page 22 to 30 relates to a number of cases and in inverted commas rather than the number of storage facilities. Can you clarify that for me, what we mean by that number of cases and as opposed to facilities, Mr. Lukele, or is it cases in brackets because we're referring to activities? If
because they were brought before the attention of NERSA, but then there was no facility to be found. On the other four, it was just expansion on existing facilities. So we didn't want to double count those. Thanks.
Oh, okay. No, thank you. I appreciate the clarity. Members, I don't see any hand. May I? Page 5, paragraph 20 of the cover. Which is my, I don't know, my iPad has just frozen. Okay, I managed to get there. In terms of recommendation, paragraph 20, the REC is requested to note the annual report on investigation done into suspected unlicensed activities for the financial year 2021/22, which for one deterring truck and taxis existing storage facility in Swinburne, Free State, and the Stedler Brewers proposed storage facility in Beaufort West, Western Cape. By show of hands, members, can I get an indication that you are first annual report and be approving those two facilities that they do not require a license in terms of the act? Thank you, Mr. Mkize. I also do support Mr. Gumede. Oh, Ms. Maseti, thank you. Supports. Welcome, Ms. Maseti. Mr. Gumede, I assume your position is still as in the earlier submission?
Chairperson, I support the note. So, yeah.
Not the approval part. Thanks. It's noted and it shall be so recorded. Thank you, members. May I request that we move on to the committee through the submission.
Mr. Nayo will introduce this one. It's an application, as you said, for trading by Pula Energy in a number of areas located mainly in the Gauteng as well as the Eastern Cape region. But Mr. Nayo will take us through this one and just indicate and emphasize the issues that were raised during the pre-hearing and how those were dealt with, because that will be important for members. Thank you, Chairperson.
Thank you, Mr. Nayo.
Thank you, Chairperson. Good morning to everyone. Chairperson, this is an application they're applying for a license to trade in gas. So it is a new entity that is trying to get into the gas industry, and therefore it will be solely relying on DNG for the supply of the molecule as well as for the supply of the infrastructure to its customers. Customers that it plans to sell volumes of gas to, as indicated on the submission. It's confidential information, I cannot mention it. Chairperson, the matter was publicized for public hearing, and then there was no comments, and then therefore we ordered a post-hearing. And the members, they raised some concerns during they raised questions during the pre-hearing, and that table that. I think some issues they pertain to the recovery of costs by Pula, and we indicated that that when an entity Pula will be charged inclusive of molecule, the infrastructure as well, and therefore they'll be charged at price. However, we were cognizant of the fact that the Gas Act allows for the separation of prices, and therefore Pula will be charged those prices, and therefore they'll be able to make a return consequent to the risk they've taken. And also, Chair, I think the other of the challenge of the business that it might be, those customers might face a flight risk of those customers as its business is a risk. However, Chair, I think those are the two customers that the entity has, and therefore for an entity that is only a trader, that is the risk that is inherent with this type of business, and therefore therefore Pula, we see that because the DNG is still also in a new entry yet. So Pula will assist the DNG also in spreading in or in getting into the industry for DNG, so that DNG can have customers for its gas. So we see that it might be a win-win situation because both entities are starting out, and therefore it might need each other for them, to also streamline and send gas into the customers. Chair, we've also undertaken the prudence assessment as it was indicated. So the business on its own, yes, it is a risk because Pula Energy will rely solely on DNG. However, we believe that on its own, the entity will be able to go and target customers and get customers for DNG and for itself, as well as move the product for DNG. So those are the issues that were raised during the post-hearing, Chair, and as I said, we've highlighted them in Table 3. And then I would say that on Paragraph 7, we had made a mistake. The energy face a challenge whereby DNG will take over its the agreements, yes, are in place as we've indicated. However, such agreements are usually term sheets at the beginning up until there's a gas supply agreement between Pula as well as once DNG has applied for a trading license, has applied for a maximum price, and only then the terms and the conditions of the agreement will be in place. And also, I think the members had raised the issue that the price that is being charged, what type of price is it, as DNG had not yet applied for a maximum price. We indicating that the rules do allow for an entity to indicate that it's to give an indication of the gas price that it might charge in case that the energy regulator approves that maximum price, so that we can be able to do the viability of the business. So that was the reason of giving those indicative prices. Those indicative prices against the prevailing price that the energy regulators are in the separate areas within the province of Gauteng, as well as
here's the presentation. As indicated, it was discussed at the pre-hearing on the 17th, and members should also look into whether the team has sufficiently covered the issues that were raised during that session. Members, the submission is here for your input. Mr. Gumede, you may come in, sir, followed by Mr. Mkhize.
Thanks, President. Firstly, indicate, unfortunately, I couldn't attend the pre-hearing, so apologies if I raised a question that had already been addressed. But I had support the actual recommendations. Firstly, The first question is, did we actually? I'm looking now based on paragraph 10.4. Is that did we actually see the financial model? Use the applicant's financial model in our stress testing it, where we actually comfortable with the. Key question though is this license or this licensee's viability predicated on or fully dependent on DNG Energy? That is for its existence. What happens if, for whatever reason, DNG Energy also faces its own issues, demise of this customer or of this licensee, or this licensee is sufficiently independent to be able then to still proceed and source product from other potential suppliers? Thanks.
Thank you, Mr. Gumede. Mr. Mkhize?
Thanks. I'm partly covered by what Mr. Gumede has said. You recall that during the pre-hearing, I raised the issue of the dependence and how they need just to rephrase so that the entity can also somehow be able to stand on its own, but with the understanding of how the two are linked and what the implications are. Just wanted, maybe if you can just talk to that. As I said,
Thank you, Chair. Dealing with Mr. Gumede's questions with regards to us stress testing and checking the viability of the project. Yes, Mr. Gumede, the applicant submitted its initial model. That was one that was indicated on the preceding available working capital that it had secured through funding. It will not be able to move that the applicant had. Gap income to move its business. So we did the viability or the stress test of the project based on the amount that it had obtained as funding, as it's indicated on paragraph 10.4. Hence, then we reviewed those volumes that the applicant had thought, or based on its initial model, that it would transport or it would sell. Especially, we just were of the view that, considering the gas market and the gas industry currently, and also looking at the other players that are within the market at the moment, that those volumes will be the applicant will not be able to move it. Hence, we had to revise it and then advise the applicant accordingly that, based on the available funding, those are the volumes that we believe that it can move, as they're highlighted in paragraph 10.4, and we stress tested that. We said, if all being equal and the amount being available and the volumes being available from DNG, the applicant will be able to move those volumes as indicated in paragraph 10.4, and it will still be profitable on them on their own. With regards to if what happens to the demise of DNG, product through into the country product, and therefore they take it to the customer. So that might be doable. However, if DNG does fold, the applicant, as we've seen, like with other applicants that we've approved in the past, can on its own, if it's got the muscle, it can import the product, or it can look into the other players that are within the industry. However, the challenge with that, looking to the other players, would be the availability of gas. That we all know that the other players that are in the industry, they are only getting their gas from Sasol, and therefore the challenges from Mozambique side. However, the developments of the applicant, and see how the business you'd rely on the infrastructure as well as a gas supply, a gas supplier, for the supply of your volumes or your products, and therefore this entity is looking at making a profit based on what the gas is buying for and what it's selling for, and therefore, yes, if DNG were to face challenges, the applicant would have to look elsewhere for its gas supplies, as well for the viability of business. So that has got
Questions, members? If there are none, may I request that we move on to the recommendations, which are on P 13, paragraph 22. In terms of the recommendation, the RC is requested to approve the application by Pula for a license to trade in gas in the Nahu within Buffalo Metropolitan Municipality and Lobega in Nelson Mandela Metropolitan Municipality, and also to approve the attached decision and reasons for decision attached as Annex 1, and as well as the certificate and associated. Show of hands, members, can I get an indication of whether you support the request to approve this application or not? Thank you, Ms. Maseti. Thank you, Mr. Kumete. Thank you, Mr. Mkize. I also support. The submission is approved, Mr. Mumalo and Mr. Nayo. I think we have come to the end of our open session, and we will move on to the closed session of our meeting. I therefore declare the open session closed of NERA. And I wish to thank our stakeholders and interested and affected parties who have joined us in this particular meeting. May I request that IT assist us in stopping the live streaming, please? And